Assalamualaikum, my name is Nur Atika binti Jamil. Dimension number S62278. I will present about a summary of the case and the issue. On April 1st, 2020, KSC company informed 4 employees of a rationalization and closure leading to their dismissal. However, the company remained operational. The employee claimed the reason of dismissal were incorrect and they have unfairly retrenched. They may have ground to claim unfair dismissal, as the company do not provide a valid justification. The employee should be informed of their right regarding unfair dismissal and operational legal action. Next is the issue whether Anas, Ani, Adi, and Ayu were dismissed without cause or just cause under Malaysian labor law when the KSC company terminate their employment on the ground of cessation of operation, which later proved to be inaccurate.
My name is Nino Izzati Nadia binti Aris. My entry number is 68397. I will present the part of principle in this scenario. We found retrenchment and unfair dismissal. In context of law, retrenchment is employers can terminate employees due to economic reason, which is financial constraint, restructuring, and so on. And for unfair dismissal, occurs when employers terminate without valid reason or proper procedures. In Employment Act 1955 was govern employment matters including retrenchment, and for the Industrial Relation Act 1967 it regulates that related to the unfair dismissal claims. The case that had been related under retrenchment was Changsung versus Technic Geoproduction. In these cases, about employee laid off due to global downsizing, and court emphasized genuine termination process and legal principle. For another cases was Bayer versus Hong Pao. It justified layoff due to excess workers. It's relevant to redundancy claims legality. For another cases related to the unfair dismissal is Gun Kui Poi versus JMP courts. In these cases is on industrial courts critique the employer's reason because the dismissals make employer to employees without valid cause and unacceptable.
Assalamualaikum. My name is Nurul Zafira binti Muhammad Zaha. My metric number is S67321. Section 20 of the Industrial Relation Act 1967 dismissed employees are given the right to make a complaint to the Industrial Relation Department within 60 days of their dismissal. They are given the right to speak if the dismissal does not have a reasonable reason or justification for the employer to fire them. Then, the employee can also apply to the employer for reinstatement to his previous job. According to Section 16J of the Employment Act 1915, the Minister may, by regulation made under this Act, provide for the entitlement of employees to and for the payment by employers of termination benefits, layoff benefits, and retirement benefits. This section outlines the compensation payable to employees who are retrenched. Employees who have been lawfully terminated or unfairly dismissed are entitled to payments outlined in the Employment, Termination and Layoff Benefits Regulation 1918 depending on their tenure of employment. The primary remedy sought in unfair dismissal claims in the restatement to one's former employment as per Section 21 of the Industrial Relation Act 1967. So they can file a complaint for restatement within 60 days of their dismissal. Next is back wages. This form of relief is to compensate employees for monies they would have earned had they not been unfairly dismissed. Pursuant to the second schedule of the IRA, back wages for permanent employees are to be capped at 24 months of their last tranche salary, whereas probationers are entitled to back wages capped at 12 months.
Hi, my name is Siti Noaim binti Zulkafli. My metric number is 66493. So now I will present the applications part. So according to Section 20 of the Industrial Relation Act 1967, dismissed employees can file a complaint within 60 days if they believe they were unfairly terminated. Despite the KC company's claim of ceasing operation, evidence indicates otherwise. To strengthen their case, employees should collect evidence like internal document, testimonial, and public record demonstrating the company's ongoing operation. Is it essential to file the complaint within the 60-day period and seek guidance from an employment lawyer? That's all from me.
Assalamualaikum, my name is Nura Aunatika binti Azman. My matric number is 61878. If the industrial court finds that the dismissal was unfair, the employees could get reinstatement. They return to their old job with no loss of benefit or seniority. Second is compensation. This can include lost wages, future earnings, and damages for emotional distress. These remedies aim to correct the wrongful dismissal and support employees. In assessing the dismissal of Anas, Anik, Adib and Ayub by KAC Company, we refer to legal case Gon Kui Poi and JNP Kos M Sedia Berhad, 1981. The key question is whether their termination was justified, especially given the company's claim of rationalization and business cessation while continuing operation. In the case of Gon Kui Poi, the court ruled that any dismissal without a justifiable reason is unlawful. The employer must prove the reason for the dismissal. The court also checked if the given reason is genuine or just an excuse for the termination. The Code of Conduct for Industrial Harmony 1975 provides guidelines for fair retrenchment. Employers should consult with employees or their representative, give adequate notice, ensure proper payments. KAC Company did not follow this procedure, making their retrenchment invalid.
Lastly, is conclusion. Malaysian labour law requires a genuine reason for the termination, not just closure due to the COVID-19. The employee have a strong case for unfair dismissal as the company reasons seem fabricated and proper termination procedure were not followed. To fight for their fair treatment, the employee should be gather evidence, file a complaint within 16 days, and consult with an employment lawyer. Depending on the industrial court decision, the employee can be awarded either reinstatement or compensation.